me.
And me.
Hello and welcome to the 60-minute clinic. Welcome to the show in the dark because I forgot to plug the lights in. I've just been going, I've been eating lamb because that is how my dinner rolls today.
Yum, yum.
Maria.
Yes.
You carry on.
While you're eating lamb. It has been a bit of a week. Okay, so let's get straight into it. We've got quite a few questions this evening which have come through. Thank you all very much for that. We will start. Let's go. Okay, 1 second. Okay, right, okay. Starting with a long one. Okay, so this is parsley. So I'm just going to say, if I can spell, of course, answering now. So, bear with, this is a long one. So it says, hello, I'm sending in a question for tomorrow's live, please. So basically, my son is going to be 11 at the end of August. I have a court order with his dad, which has been since he was 1, although he's been changed and adapted. It's been changed and adapted over the years. Complicated, and the judge told Dad last time he's treading water and would need to request permission before applying to the court again. Now Dad has been made homeless and hasn't made an effort to see our son in a month. No reason he couldn't have him after school, where there's been lovely for walks, parks, etc. This has created a lot of tension and negativity from son. He's now decided Dad's now decided he's moving into a friend's house. He's going to have a section of the living room with a bunk bed to share with our son. I've expressed concerns about how he will sleep, as the other adults all stay up late and it jumped. Other adults stay up late and are gamers. I've asked where he will get privacy, where he can do his homework when he starts high school, etc. Dad refuses to communicate and just says it's going back to normal and the court order. Not bothered with what you say. I'm not suggesting that Dad doesn't see him. I've seen the upset and stress that this has caused our son, but I've suggested maybe until he has his own place. It goes down to Friday to Sunday every other weekend, so it's not affecting sleep/school, and then there for tea in the week, etc. Dad refusing to engage and telling me it's tough and it's his way and going back to the court order. So my question is, would the courts see this as a suitable arrangement? At my house, he has his own bedroom, etc. He's been so flaky during primary school and often doesn't take him to school because he couldn't be bothered. I don't want it to repeat for year 7. Wow. Okay, that's a lot. First off, Dad's been made home, but he's okay. So he's living in with friends, and he's got a space in their living room where there's going to be a bunk bed to share with him and his son. I mean, it's not
welfare. This order's been going since it's 1.
Yeah,
that feels like you've already, your son has obviously aged out of the order as it stood.
Yeah.
I mean, I can imagine that your ex is quite difficult to discuss things with. I'm not getting hugely helpful co-parent vibes, but somehow you've managed to keep it going, which I think is a real testament to you and your desire to let this relationship play its course. Don't know about you, Maria, but I think I can see a judge saying, well, Dad, you've basically moved into student accommodation.
Yeah.
You know, for whatever reason that is, you've moved into a space that your son really doesn't need to be in, especially a young man.
Yeah.
Doesn't kind of need to be getting gamer all night, player all day vibes.
No.
Really?
Absolutely not.
Time. Yeah, I think the fact, have you been back to court a lot since the order was made, or was it just like a one-off? I think that would be my question. Do you have form? So while you're doing that, I'm just going to let this person know. Please ask them here. Somebody's asking how you ask questions. So let me just respond to that.
I mean, I'm going to assume that they've been to court a bit, because the court have turned around and said that the next time Dad's already treading on water as far as applications are concerned.
Oh yeah. So
I that kind of indicates to me that there is the barring order potentially in place.
Oh yeah, that's true. There may well be a section 9114. We don't quite know. It feels as if you're not insane. Right. Number one, welfare says that it's reasonable for you to take a nuanced view to what's good for your son at this point. You don't need to build up the relationship. He's been having a relationship. What this is about is as your son navigates into those trickier years where we're a young teenager. He's kind of pre-teen at the moment, but boy, is everything about to change. You know, pre-teenager, what he needs is as much, I think, and I'm going to put this out there, when you're from a family with separated parents, as I was, you ever so slightly, in terms of total life chances, you start behind those families with two parents. Not as much backup, not as much harmony in the home, not as much fiscal, everybody pulling in the same direction. Little things, really small things that make single parenting harder and more difficult to achieve the same outcomes. But don't get me wrong, of course, that's a generality. There's super duper ample examples out there of people who stuck together, and my word, it was just like having an extra baby or an extra idiot in the home. So, but at this point in time, young men with all that competition from the internet don't need stuff that is going to make them less likely to engage in school. Whether it's less likely to engage in school because we're getting modeled that gaming all night and being like a student is a good shout, or we're having competition with school because we're knackered and we're not sleeping properly. So I think those arguments that you want to make are valid, but you'll need to be careful about how you develop them and present them, because what you will need to avoid is showing, you can do it without criticism. You say, I'm not criticizing, he is where he is, dad's got this problem and that's his life. It's not for me to say it's better or worse for him. But for our son, what our son needs is a more home-like environment where what's modeled is that gaming is fun, not a life choice. And I think that's something that you can get out there, but be careful how you say it. Because it's not about this man's a maniac, is it? It's not this guy's on coke. I mean, maybe he is, but on what you're saying, that's not the issue. It's the little, we're now in the fine margins of parenting. We're not in the really try hard not to drink 6 pints before you change a nappy zone of parenting. We're in the, this is what splits out the kids who've got better life chances and less good life chances. And life chances come from when they're 11, 12, 13, 14, small incremental things that have been built on the big correct stuff between 0 to 10. Between 0 to 10, you can make a lot of nuanced mistakes so long as you get it sorted by the time they hit 11 and start challenging you. But dad is not modeling seriousness about school. He's not modeling seriousness about work. He's not modeling seriousness about adult life. And your boy has got all the competition in the world already in terms of what wants his attention. School wants his attention, but so does Meta. So I think those are arguments you can develop. I think you should develop them. I don't see why you wouldn't stick up for your son. And I would say, I don't know, process-wise, I might offer child inclusive mediation, I think.
Yeah.
I don't know if that helps, but yeah, it's welfare, not domestic abuse. I think that's the other thing I'd say. I'd present it as welfare, not as domestic abuse. Hope that helps. Okay, I will do this question here. Oh gosh, all right, this is quite money-ish. Negroni, let's do you again. Let me just let you know. Negroni, doing you now. Oh, poo, it didn't even print, didn't even type. Doing you now, there we go. Right, Negroni, your question is this. And by the way, if you're watching and you quite like to ask a question, get into the direct messages. You need to, I think, like the page and follow the page. I'm not quite sure which. Then you can get the direct messages. Direct message us your question. We'll give you a code name. As you've probably figured out, our code names are ridiculous. We've clearly gone through some hefty cocktails at some point. I'm now, by the way, doing flowers that I can see outside my window in my ever so slightly too dry hanging baskets. So Fuchsia, you know who you are. We'll be coming to you soon. Anyway, Negroni says, and Negroni's had a go on this before. So Negroni says, oh, this is a long one. Hello, I'm sorry, this might be a long question. Me and my ex separated 5 years ago and divorce was finalized October 24. Okay. We've got 3 kids, eldest 2 are adults. The youngest is almost 9. Okay, that's a big gap. Current schedule is 10 o'clock in the morning of Sunday to Tuesday, 7:30 every week. This has evolved due to his requests. It's been in place since November 24. I've always hated the split weekends, but have made the best of it. Our eldest recently moved out of his house, our house. So now he can give the youngest her own room, and he wants to move towards. Our eldest recently moved out of his house, so Mr. Negroni's house, and so now he can give our youngest her own room, and he wants to move towards more equal shared care. He is proposing adding every other Saturday to the current schedule as he sometimes works away, so Wednesday, Thursday, Friday are not possible. I've counter-proposed with every other full weekend for each of us, and I'd be flexible if he wants extra Tuesday or Fridays as his work allowed. He keeps restating that every other Saturday is the only way he can increase his parenting time, and he wants every other Saturday moving towards 50-50. I'm not opposed to more time, but only with a full written schedule with both of us having full weekends. He's already spoken to our child about having extra time. Bloody hell. With both parents having equal time. What wording should I use to avoid accidentally agreeing to a permanent change? And then you're going to go on to ask a money question, which we'll get to shortly. But on that first question, I'm not too worried about agreements, although be careful what you put in writing. Sometimes judges down the line might say, well, you kind of switch and you swatch because first you said this and then you said that. So yeah, do try and get a coherent proposal that you're willing to stick to. I'm guessing that your position, I might be wrong about this, but I'm guessing from somehow, just from the tone of what you say, is that actually shared care might work out quite well for you, because let's all remember, what do we get when we don't have to look after our children as much? We get time back. And what do we have when we have time back? We have a much greater opportunity in a big picture kind of way to develop our careers. And why do we need our careers? Because no one's coming to save us. All right. So, I would, again, I'm going to go child inclusive mediation. I would say is not a bad idea here, and say I'm really prepared to talk about this, but we've got to do this with our kids' welfare, what this child needs right now. And I am totally prepared to listen, but I need to be convinced that this chopping about is going to work. So I want to talk to you about it, but I want to do it in a way that actually works for our child and in a way that allows me to think about things. So let's mediate. Let's go and mediate that. And so I think that's what I would do. And I hope that makes sense. Do you want to take the second bit, Maria, and do the money bit?
Yeah. Okay. It also says, and my second question is around his right to inspect the property. The house was put in my name, and he has a second charge for his percentage when sold. After 5 years and two since the agreement was finalised, he has now decided he will exercise that right and give me notice, and has given me notice. I made sure that it was a written agreement that he could send a representative, so I know I have to allow access, but he is also asking for a written summary of repairs, details of damp or water ingress, boiler and plumbing condition, planned works, confirmation when utilities are working, anything else his proxy should know. Does the order require me to answer these written questions or only to provide access? Is the proxy's inspection limited in scope? How can I ask that inspection is limited to what the order permits? If photographs are taken, are there any restrictions on their use? This makes me the most uncomfortable as I feel judged and nervous that he will use...
Let me stop you there, right? I am really, really confused about the wording of this charge. This looks like a commercial charge on a commercial lease. That's weird. How on earth has somebody been using ChatGPT to draft their charges? And why were you not married? Were you? Sorry, I should have. Were you not married? Was this? What the heck? This is mad.
It seems to be like could be a potential like a leasehold.
It's a bit like it's a talata, isn't it, or commercial lease? It was very commercial, this language, and why? And so he's exercising his right to inspect the property. I mean, there'll be an implied covenant of reasonableness, by the way, which is like you can't just give a notice every Wednesday and come round every Friday. Okay. No, I don't see, unless it's in the contract, I don't see why you need to do a written summary of repairs, details. I don't see why you need to do any and all of that, unless it's actually in the thing.
So it's in the second charge paperwork by the look of it.
So keep the property in good state of repair, renew, pay all the doodahs. Also, this is very American, government municipal. There's no such thing as government municipal. Permit the lender. I can see nothing in your wording that says you have to do a written summary of repairs or details of damp or water ingress. He's got a right of inspection. Come and inspect, and then sod off, basically. We were married and the legal charge caused a lot of contention and cost an awful lot of money for me to fight against it. He's not inspected or asked for any of those since then. Yeah, this sounds a lot like he's trying to spy on you. I don't know. I would read really carefully the lease, the charge. If it says in the charge you have to provide a written list of this, that, and the other, go ahead, obey the charge you entered into. But it looks to me like he's got a right of inspection, not a right to make you give him listicles. He needs to inspect, and if he's decided, maybe he'd like to put his hand in his pocket and send a surveyor around, fine. But he's not. I mean, he's not a mortgage holder. He's got. Yeah, he's just asked for it. Tell him he can inspect, and that's it. I mean, he's not. This charge looks really funky. It just looks really funky. I'm guessing you were married, and I do wonder why it's become so commercial. That is just odd. I mean, I would not lift a finger more than I had to. There you go. That's what I would say. I think it's quite an onerous charge. I don't think that would have been. I'm surprised that your lawyers let that through. I think it's quite onerous as it is with all the repairs. Why doesn't he have to contribute to repairs, given that he's getting some of the benefit? So, don't know, Maria. Agreed?
Yes, it's quite a weird. The wording of it isn't spectacular. And it isn't clear actually. The charge itself is that from the information that that they've provided isn't very clear.
It's got very, I just find it's as if somebody's lifted it from a mortgage deed or something, or a commercial lender's mortgage deed. It's odd. It's very odd.
Because it says, as far as the right for inspection, it's notice to the borrower, and he's not. That's not
a borrower. That's mortgage talk,
landlord.
Isn't it?
What that could also be landlord tenant type thing, but
well, it's building society talk. That's what that is. That looks like somebody your timing isn't quite ChatGPT everywhere timing. And by the way, after this question, we're going to have a whole. Let me do a little rant about ChatGPT. But your timing for your charge being done suggests to me it wasn't when ChatGPT was everywhere. You might tell me different and say that he was very ahead of the game, and that is something that he used. But I'm finding it. I'm the borrower, he's the lender in the document. Well, he's not really a lender, is he? Because that would suggest, look, borrowing and lending is subject to consumer rights. So he's either your consumer lender, at which point you have the protection of all the consumer protections, etc., which things have to be written into fairly, or he's a commercial lender, which he is not, simply because that is not what he is, not a limited company. He's just a human person. Or this whole thing is actually protected using the Matrimonial Causes Act. And I bet there's liberty to apply if there's a dispute over some of this. And I think I think the remedy for either of you would be to go back to court under the liberty to apply provisions in your consent order or final order, and argue about it in front of a district judge who will simply impose a reasonable solution. But I'd be like, yeah, whatever, mate, you can come round, but I'm not going to do your dirty work for you. You want to slag me off, carry on. But this is reasonable wear and tear. It's the other thing, isn't it? See, he wants all the goodness of Bicey commercial, and with none of the pesky consumer protections or purpose. And it's as if he's trying to get out of the Matrimonial Causes Act. I'm not impressed. I don't think he's got as much of a leg to stand on as he thinks, put it like that. You do have to let him in, though. But there you go. That's the sort of language I'll be giving back to him, going, you're not a commercial lender. This is governed by the Matrimonial Causes Act. If we are in dispute, you can come in. But otherwise, I think you might have used your housing lawyer to do this charge, and it doesn't make sense under matrimonial law. Anyway, there we go. Okay, great. That's great. Thank you, says Negroni. No problem. Hopefully that was helpful. All right. Okay. This is just a quickie. Who's this? Elf. Hello, Elf. Doing you now. Hi, please help. I'm midway through section 7 and the social worker has asked if I agree to a visit with Dad to assess their needs. Why would you not let a visit go to Dad's? Why would you not let the CAFCAS officer see them with the children with their dad? Let me know why. Tell me what the problem is. And everybody just remember, we don't have time to scroll all the way up to what happened 3 months ago. So it's really helpful if you're coming back for more, summarize where you're at. If it's relevant, summarize what we said we thought you should do, summarize if we got that right, or hopefully not too far off the mark, and summarize what the question is. That really helps us, especially for people who've got sort of form with us. Anyway, can I just pause for a minute to do a quick ChatGPT rant? Maria, How much
Yes.
of that is happening in your life at this moment in time?
I would say at least 80%.
Yeah. So I saw some statements yesterday. In a Children Act case. Those statements were, the particular statement I'm thinking of was approximately 30 pages long. But it gets worse. In spite of the fact it was written for a fact find, it completely failed to specify a single incident in a way that a judge or a lawyer could go, "You're not invited to this bloody legal fact find party, dogs, shut up." Sorry, legal assistance dogs helping as per. It didn't have a single factoid in it where you could go as a lawyer, this is what you're being accused of, Mr. Client. What are your instructions? You know, can you tell me, like, she says this happened. She says it was that date. Do you think it was the same date? Do you remember something about this? Was it like she said, or was it a bit different? None of that. It was couched laboriously in the most general terms. For example, he's controlling and coercive. He's abusive and belittling. It's like, well done. You've got all the buzzwords, but you're not managing to tell me what he did. You're literally not managing. You're managing to tell me how he makes you feel and what you think it is, but you're not managing to tell any of us how I'm supposed to say to my client, well, this is what you're being told happened. What do you say? And the other thing it did, which was infuriating, was all the way through it, it would say, and practice direction 12J says, do. And in accordance with the Domestic Abuse Act 2021, the court should be deciding that. And what else did it say? Oh, my good Lord. It went on at one point to say the theoretical basis for disputing or for denying contact in a domestic abuse case. And I was just like, the theoretical basis, you say? How very helpful. It genuinely was just telling the judge how to do their job. It was telling nobody anything about what happened, and it was making legal arguments. I mean, it waffled on about attachment theory and Charlotte Proudman. I nearly died. I was just like, none of us any wiser. Needless to say, it was begin again, fin again, right? It was just like, go back to square one. And happily, at the point that I got it, the other side had been equally, well, not quite equally useless, but going down that road. So it was a bit 6 of one, half a dozen of the other. But yeah, the judge was not impressed and just said, no, none of this. You're not ready for a fact find. And by the way, they were at a 3-day fact find. The judge just opened it and went, what am I supposed to do with this? What am I supposed to do with this?
So where a proper schedule of allegations really is.
There was a rubbishy, like non-schedule of non-allegations. It was hopeless. Yeah. So basically, everybody's got to go back, redo their schedule. And then, well, in fact, we did the schedule in the room because we had 3 days. So we got that much done with the approval of the court. And then we've all got to go off and sort out our statements. But be warned, ChatGPT will lead you down paths that are very useless. And everything that's good about it, such as spelling and formatting and thinking things like letting your blurt turn into something good, everything that's good about it will go out of the window if you do not put it on a lead and keep it really close to you. It's very, very important that it's actually best to even dictate. Find your incident, right? I mean, here's how to approach a fact find statement, okay? Pick the first bit that you knew the red flags were coming, okay? And pick the last bit. Right, now you've got from flag here to flag here, you've got a timeline, right? Start putting some times down. Start a timeline. Right above Christmas 2024, he got properly pissed this time. And I know that was something I'd begun to realise was impacting the family, you know, or I don't know, it was Easter and he sat in his pants and refused to speak to me for 4 days. You know, let's get the facts. What do you remember? And what you'll find is that the more you do that and the more you go back to it, you will suddenly remember. Because don't get me wrong, lots of judges, not all, I know, they will accept that trauma makes you forget things. And I as a practitioner would absolutely guarantee you that if you've been in a traumatic situation and you're just for the first time beginning to splurt about it, you'll only be at the beginning. There will be stuff you'd buried in your head. People do that. I mean, I would say, Maria, do you say the same thing?
Yeah, absolutely. A trauma is it can be so difficult to unpack, especially if you're just coming out of a really abusive long-term relationship as well, and that you're just kind of just are now understanding exactly what's going on, and that can be difficult to be able to even put down in words for some people to start off with.
Well, they don't have the words, do they? They don't know how to explain the dynamic, because for them it's been unexplainable. All they know is they've been kind of in this frozen state of not being able to move forwards or backwards. And I think it has this really crushing effect on people, on their self-esteem, which leads to their ability to self-advocate and their ability to go, that when you're maybe 18 and kind of sassy and you don't have 3 kids and not quite enough money, if somebody comes up to you and goes, listen, the earth is flat, you'd say, option A, oh yeah, no, I hadn't really thought of it that way. Option B, fuck off, you moron, right? Simple. Most of us will choose option B. But when you've been through that kind of constant rubbing away of you thinking what is sensible is now maybe not sensible, and constant questioning of whether you're an idiot or not, that's what self-esteem wear away looks like. Then he'll say, no, the earth is flat, you silly bitch. And instead of going, no, fuck off, you moron, no, it isn't, you'll be, yeah, no, I thought so, thanks. Like, let's move on. I just agreed with you. Please don't press me anymore. Yeah. And that means that by the time you come out of it, when you finally pop, if you do, please God, you do, you finally pop, you leave with nothing sorted, because that's how it generally works. You're so exhausted. People are so exhausted that they just don't have the headspace at all to blurt what happened. They do it in almost like tiny islands, like tiny fragments. So to get out of that fragmentation and that incapability, which doesn't mean being thick, by the way, it just means incapable right now, start with beginning and start with the end, and allow it to be a puzzle. Allow it to be a 1,000-piece Ravensburger, whatever they're called, puzzle. That's okay. Start with the corners. Let's do some of this. Let's not do the sky first, right? Yeah. And I think that's a great metaphor for, is that metaphor? Is it an allegory? I never quite know. For how to do a statement from a place of trauma generally. You cannot just go bing, 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 because there are 1,000 pieces to this puzzle. And the problem with ChatGPT is if you go make my puzzle, it will make your puzzle, but it will make a different puzzle to the one that actually you need to tell the judge. It's better to do a blurt fest and then say to ChatGPT, here's my blurt fest. There are gaps in it. I don't mind you keeping those gaps. Make it a bit more coherent, but do not on any account change the facts. That's a good way of using ChatGPT. But I am seeing people who are having it lead them astray. And I guarantee you that if I see a ChatGPT statement that is that crap, I will be making costs applications against the person who plonked it in front of the court and tried to make me deal with it as a respondent. I'll be on costs. I'll be saying your conduct of your litigation is no good. Practice Direction 44 entitles me to ask for costs, and I'm going to have them. So be careful, okay? Let's not let it drive the bus or try and tell us what the puzzle should look like. It's our statement. It's our facts. We were there. You won't remember all of it, but 1,000-piece puzzle, you start with the corners and do the outsides first. And that's not a bad place to start at all. And give yourself time. Somebody says, can you do your statement in 2 weeks? Say, can I have 4? Ask for, think of the number that everybody's telling you to agree to and double it and fight for that. Anyway, that's my little, that went off on a bit of a tangent, but boy, is ChatGPT doing my noddling. There's no time. Any comments? Welcome in in the comments. Anybody's got a little tale to tell, keep yourself anonymous if you want. You can put it in the DMs if you want, but definitely, yeah, I don't think I'm the only one. I don't think I'm the only one. Okay, what's next, Maria?
Okay, so have I done that one? No, what's the using? Okay, we need a username, please.
Code name is Geranium. Very much what I can see.
You're testing my spelling, Ursula.
Seriously, you have honestly, you don't know your born mate. I was doing Latin out of the book of Moths and Plants of Great Britain. Thank you very much. The Wildlife Book of Great Britain. I was going, let's use the Latin names. It was hard for me, and it was hard for the person who got the names, like long names. Honestly, I don't know where my brain goes sometimes. It just has plans.
It does. Yeah.
Yeah. I'm like, I didn't know we had these plans. It's like, we're doing this.
Okay, so Geranium says, my son has had his son from Wednesday to Saturday since birth. He's now 4. He starts school in September, but Mum is insisting that she has him 5 days a week when he starts school, so changing his normal routine. Both parents have chosen a school, each as they share 50-50 parental responsibility. The education have stated they must agree together what school to send him to, as Mum applied behind Dad's back. They are awaiting mediation, but worried it will not be sorted for September. Mum's school is 45 minutes away from Dad's house and 10 minutes from near Mum's workplace. Dad's school is 5 minutes walk away from Dad's house, and he has friends to start school with. Where do you think he stands, and what questions should he ask to benefit his son with school and days? Is she allowed to change days to suit her and choose a school without his knowledge?
Okay.
I think my first question is that if Mum chose the school behind Dad's back, did Dad choose the school behind Mum's back, or was there an agreement there beforehand?
Yeah. And my question is, what does everybody do for a job? That's my question. I will start with a little bit of reframing, if I may. I'm also going to ask, I am assuming that there's nothing wrong with Mum's care and that there's nothing wrong with Dad's care. Okay. I am going to reframe this by saying, what does a 4-year-old, a rising 5-year-old need at this point in their life? Because that rising 5-year-old is about to go through a big life change, which is the beginning of formal education. And in my view, what a child needs is not to bear the load of the fact that these two parents cannot agree enough to live together, right? That the failure of their relationship is not something that your grandchild should bear. And I think by framing it as, what can Dad do so he has the child, or what can Mum do so she doesn't get the child, is causing, the only person who's going to be the loser here is the child. I would also say that it's time for one of these adults. This is my personal view. I know not everybody thinks like this. I think it's time for one of these adults to say, this child needs less chopping and changing. This child needs to know where home is. This child's bags need not to be permanently packed. This child needs to know where his bedroom is, where his stuff is. And one of us needs to accept that. That's what I think. I know that not everybody thinks that, but I think that's right for children. I think doing that any other way means that the adults get what makes their emotions feel regulated, and the child gets to hoover up the shit. That's what I think. And I think what's worse for a child is parents on a constant low-level bicker load. I think that is that's so debilitating to children's sense of internal everything's going to be all rightness. It just leaves a constant sense of slight dread because either parent is liable at any minute to bitch about the other parent because they just can't let go. It might be that your son likes the 50-50 because it permits him to, it might suit his working pattern. I don't know. So I think it would help if I knew what working patterns were, because I think when you get to this 50-50 stuff in a close-knit relationship, I mean, what's obvious is your grandson will have a great relationship with his father. He doesn't need to see him every day, doesn't need to see his mother every day. But what practically on the ground would make all of this better for everybody? It might be that dad can work more and should work more and pay more child maintenance, and see the son quantitatively less, but qualitatively just as much. It might be that he wasn't actually doing much of the caring and you as the grandmother were doing a whole load of it. That's possible. And if that's the case, I think that needs honestly assessing, because that it really does mean that there's a sort of level of dishonesty about who's caring and who's really wanting the 50-50 here. And I think we have to be honest about that. This child is not going to enjoy being a piggy in the middle. I'll tell you that now. So I think it's a worrying approach to say, what can we do so we, bugger it up for her? I would be going, which of these schools looks the nicest? I think I'd be saying that. Which has the best Ofsted rating? Which is in the nicer area? Who has got the biggest bedroom? Who has... I mean, I'm assuming you would not turn your nose up at supporting her as much as supporting your son when it comes to childcare, if possible. I mean, if you on no account will be looking after your grandson when this grandson is kind of on her watch, then I have questions about you. But what I'm sensing is that it's really unfortunate that people aren't working together and going, where is the best of these two places? Because that's where he should be going. So I sort of, for me, it's like I'd reframe. I don't think the way you framed your question gives me confidence that your son is definitely right. I'm not sure he's definitely wrong either, but I'm concerned about the way the question's been framed. And I don't know, I accept this is one of those questions, isn't it, where what do I know? And you're perfectly entitled to go fuck off, Ursula. That's fine.
It's also about making sure that at the forefront of both the parents is the child. That's the important thing. It's
they've
where
shared this long,
exactly.
They've shared this long, and kids change. Kids need something different. They don't need. They can really do 50-50 well, especially if they're used to it, from birth to Rising 5. At Rising 5, what children need is stable bases. Yeah. And one of you should really think about if it's time. If what's mum's environment like? Is she the studious one? Is she the one who's got more time? Is your son on a shift pattern? I don't know. Who's got time to do the poxy homework? Because let me tell you, those phonics, they wait for no man. They are. Yeah, right. Anyway, and that's what I'm saying. So Martini says, let me go to Martini. I have my fact finding coming up. Any advice? I'm nervous about it all. On another note, I filed my N208 application and it's been accepted. And we have a hearing in September. What typically happens at that hearing? Bloody hell, what's an N208? Why do I not know? What is that? Okay, got normal. Right, what's an N208, please? SOS. What's an
Part
enter?
8 claim form.
Help with fees. Oh, good. Part 8. Excellent. Okay. Yes. Good. Okay. Well, Part 8. So this must be a Talata case. They're not married. All right. So what that means is that Martini, on the Housey side, the first hearing will be a directions hearing, and the judge will need to order. I think you should be ready. Do you know what would really help? Really help. And I'm also having this as a whole new vibe as well. When you make an application, it is usually stuck right in the bowels of the court rules, the CPR or the FPR, that if you rock up to court wanting an order, you should bring a draft order with you. You will simply score fat points if you do a draft order. And as a layperson, you're not going to know how to do that. But I would definitely, invest in us, obviously, but if you can't afford us, I get it. I would invest in a Mackenzie friend. I'm going to put a shout out there for someone called Michaela Wade. Maria, I don't know if you could find her little jobby and put it in the comments. But Michaela Wade, I've seen Michaela Wade do her thing. And I actually think she does a really good job and she knows how to draft orders. She's Mackenzie friend. She's totally respectful of the boundaries of what Mackenzie friend can and can't do. But I would definitely think that's money well spent if you couldn't buy a family first lawyer. So even if you said to her, Michaela, I don't quite know what I'm going to ask the judge for, but if I do a word version of a court order that goes before I turn up, at least the court knows that I've had a think about it. In your claim form for the house, I think from memory, I will actually break the habit and scroll up. That's right. You want to force a sale. I think what you're going to do is you're going to say to the court, if we can't agree today that the house should be sold, we should both do statements. So he should do a statement, I should do a statement, and list it. So order 1, both do statements. Order 2, list it for a hearing of 3 hours, because I think if it's part 8, it means there's no argument. It's just force a sale. And costs. Order 3, costs in the case. Okay, so costs in the case means at the end of the case, the judge will assess whether you should have your costs paid, and that is important in Talata things. So that's what I would be expecting the judge to do. And I also, by the way, think that Mr. may well cave, but you should ask for your costs and tell him if he doesn't agree to settle before you go to court, you will be continuing to ask for your costs. So I'll definitely go and see Michaela as well. Anyway, on the, where are we? On the fact find, okay, what's going to happen is somebody's going to ask you questions, and you might have to do questions as well. Have you thought about how you're going to question the other person, the other side? Is there a QLR, a qualified legal representative, already appointed? I would want to know that. If you don't have a QLR, you better start reading. The best thing to do is to read the statement that he's made. And first, again, a bit like the 1,000-piece puzzle, what you do is you say, well, my first question is to just shout, put little Post-it notes that say, that's BS, all over, sorry, I'm just realizing my thing will die, all over his statement. Don't mark the statement up yourself with a pen. Just use Post-it notes that say, this is rubbish because, okay? And once you have Post-it notes all over his statement that say, this is rubbish because, it becomes really, really easy to ask the questions that you need to ask him in order for you to demonstrate that it's rubbish. So, cross-examination has a reason that people get paid quite well to cross-examination. One of the things would be great is if you have a barrister. Don't know if you have a barrister. But basically what will happen is you will be asked to swear that your statement is true. So something really important is to read your statement and figure out if there's any mistakes in it, or is there anything that needs updating. And whatever you do, before you swear that your statement is true, just say to the judge, Judge, I put April for one of my things I said happened. It was actually June. So I'd like to change that. And number two, you might say, and can I give you an update, like a really brief update about what's been happening since I made this statement? Because there was one other incident that I think the court might need to know about. You could do that. Once you've done that and your statement has been sworn as true and you've added those little bits, it will be as if you literally just read your statement out. That is your evidence. You then wait there and you will be asked questions about it. And really, there's only a few rules. Number one, always tell the truth. And I think number two, listen to the question. Please just listen to what you're being asked. If you're able to speak about a question and explain something, then try and do that. But try and stay on topic. Generally, try and stay on topic. I mean, easier said than done, right? And if you could take a Mackenzie friend with you, or a friend as a Mackenzie friend. I think that would really help you. And take a notebook and a pen, and make sure you have a copy of the bundle on your phone or on your computer. You genuinely want to have some stuff with you. Don't just, like, honestly, I've seen people rock up with just their phone, and I'm like, what were you, have you not got anything else? You haven't bought a pen or a notebook or anything. So I think there's that. Oh, okay, you've got a barrister. Yay. He has a QLR. Okay, and he's convinced his grandparents to sign a false statement. Well, they'll have to turn up, won't they, and tell the judge. Will his grandparents turn up? That's my question. Because I suspect that they won't, because they know they're talking bobbins and they don't want to have to swear that it's true in front of a judge and everybody. So yeah, read your statement, read his statement, help your barrister by saying, here are the areas that I think he's really weak on, because none of that happened. I mean, your barrister will know how to do that. And really, it's just about listening to the question. And have a think right now, are you going to swear on the Bible? This is the only bit that looks like the films. I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. That's one of the oaths. The other one is, I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. After that, it's not like the films, but that bit is like the films. There you go. That's what I've got to say about that. Maria?
Yeah, fact finds can be really difficult. So just breathe. Remember to breathe.
Yeah. Oh, and sort out
really,
childcare, for goodness sake. Sort out childcare and have friends on hand with wine and bonbons for afterwards.
Yeah. You need to be able to kind of just chill at the end of it, because it is if it's a full day of a fact find, it can be really, really draining, emotionally and physically. And you just don't. I know you're just standing in court, but yeah.
Yeah. Right. Okay. I need a code name, I think. Hang on a minute. Okay. Code name Petunia. Let's do Petunia. Petunia is your code name. Right. Oh gosh, we've only got 5 minutes, but yeah, I've been rabbiting on. Petunia, doing you now. Hello, I'd like some advice as to what I'm meant to do. I have a special guardianship order of my grandchild. His mother is taking me to court next month with regards to contact. We've had CAFCAS. What do I need to do next? I sorted out contact with the SGO guardian, and out of the 5 contacts, the mother did 1. Okay, that's very sad, Petunia. What I would suggest is you keep a really good record and start having a think about what contacts were like. You're going to start building a statement. You don't need to do a statement till the court says to do a statement, but definitely turn up to court, definitely engage with the guardian, the special guardianship order guardian, the CAFCAS officer, and think, always be answering questions with a view to what's best for your grandchild, because it seems to me that what's the most important thing here is stability, because nobody has an SGO to their own grandmother without some serious shit going down. And I think we all know that. So your grandchild steps, he or she starts a few steps behind all the other kids, right? So it's your job to parent extra better, extra harder, to make up for that gap in their life. And you just need to explain to the CAFCASS officer, I'm sure you're doing that, about how you do that and how much you understand that without criticizing the mother, this mother's not stable. This mother is, her own problems are too deep for her to parent well. And that's something that you need to get across to the CAFCASS officer, guardian, I would say. That's what I think. That is what I think. And well, we did Cyclops last week, I think.
Yeah,
we did Cyclops. That's all good. Let me unstar that. I'm done. There's a person who's asked me lots of complicated international law questions. I did last week. I did the thing where I just answered something really important that person needed to know using the messages, but I'm just not doing detailed advice in the messages. We do this verbally, and I'm really sorry. We can't be doing, I can't be typing. I type all day.
we do enough typing during the course of a day.
We do. Oh, look, back to Petunia. Petunia's had him for 7 years. He has a lot of special needs and ADHD, etc. His mother had 6 kids, including my grandchild, taken probably away from her. Well, yeah, he's had an adverse childhood, as they say. So you need to really be thinking about what you do to compensate for that adverse childhood. I think it seems to me you have already got the ear of the court, and I think it's going to be fine. I think the court is just trying to be fair, make sure that decisions are made fairly, not not just going, yeah, mum, in the bin. All right, they're trying to be fair about it, so I wouldn't worry too much by the sound of it, unless you yourself have suddenly taken up gin and running naked gambling houses in your house. I think you'll be fine. All right. If you have, don't say that online. That seems bad. Oh, what we got now? What's next? Oh yeah, hang on. There's just one more, and my computer is just being massively loseristic. Can you see? Oh, okay. This is back to Martini. Do I need a draft order stating I want the house to be sold then? Sorry. Yes, you do. Ready for the hearing in September? Yes, you do. You did attach all your evidence to the application as to why, and it's quite thick. Oh, maybe the court will maybe, if it's really open and shut, and I'm not saying it is, you could try and persuade a court to make the order on the day and say there couldn't be anything clearer that the court should exercise its powers. It's got all the evidence it needs. It should exercise its powers to make an order for sale now. It's in accordance with the overriding objective. It is proportionate. It's improper to use more court resources about something where the answer is as plain as the nose on your face. It ensures that the parties save expense. And the fact that I've had to come here today, I'm going to ask you to make that idiot over there, not you, Maria, pay for my costs. And if he carries on, the court will use up its resources. I will keep asking him to pay my costs. So I'm doing him a favour because I'm saving him money as well. Just make the order, please, Judge. So yeah, get an order that says that. 100%. That's what I think. Yeah. But yeah, if you can get somebody to help you draft it, they won't be sad. Hello, Rachel. I can see Rachel is in the chat. Nice to see you. How you doing? And yeah, so the Mackenzie friend, I would happily recommend Michaela Wade. I've seen her do a thing, and I think she's very good, and she doesn't piss judges off, and there's a lot to be said about that. So, I'm not saying you shouldn't have a qualified lawyer, but let's be sensible. Sometimes you just need a tiny bit, and accessing just a tiny bit can be a bit of an ask. And also, I know for a fact that we're stone cold busier than we've ever been. So right now, don't be asking us for the tiny bit. We could do it, but we're all knackered. And as you say, we've been typing all day. So yeah. Anything else?
I think that is it.
Awesome. Okay, well, the next 60-minute clinic is on the 30th of July. Where the hell did that go? That means there's only 7 weeks to the all-nighter that we're going to pull with the 24-hour 60-minute clinic, which is happening on, is it the 18th and 19th? Eden keeps telling me, I keep forgetting. Marketing
Yes.
Fred has plans.
Yes.
Yeah. And you know who's agreed to come on it? Jonathan Todd from 29 Bedford Row, top barrister.
Nice.
Top
Yes.
barrister.
Top
Yeah.
barrister.
He
Yeah.
has agreed to come on it. So we have to think of some good money questions for him.
Okay.
Get some really good top barrister money questions in. Something smelly and difficult.
Mm-hmm.
That's what
90% of my cases.
difficult, right? But in good news, it's the end of the 60-minute clinic, and that therefore means that it's nearly the weekend because we just got to get through Friday. So thank you everybody for joining in and listening to my inane burblings and Maria's more sensible, non-inane burblings. No problem, Martini. And keep us posted. And please do let people know in your groups. Tell them about us. Share it. Tell them we're here and trying to help. Tell them we're very tired. So please don't expect written answers. And we'll be more than happy to help. So it's goodbye for me until next week.
Goodbye from me too.
Okay, bye.